Hello everyone. The topic which I have brought for you today is Doctrine of Constructive Notice. Let me first give you the meaning of the term doctrine. Doctrine means theory or principle. The term constructive means presumption, and the term notice means information. So, doctrine of constructive notice means law presumes that every person who deals with the company has knowledge of the contents of memorandum and articles of association of the company. Later on, he cannot plead for ignorance. When memorandum and articles of association of a company are registered with the registrar, these documents become public documents. They are open and available for inspection to all in the registrar's office or through electronic means on payment of the prescribed fee. This provision is given under Section 399 of the Companies Act 2013. If any person wants to deal with any particular company, he must read the memorandum and articles of association of that particular company by logging into the website of the company. It is therefore the duty of every person dealing with the company to inspect these documents, memorandum and articles of association, and make sure that his contract with the company is in accordance with the provisions of these documents. He will be presumed to have read the documents and to know their contents. This doctrine protects a company against the outsiders. There is a leading case law of Doctrine of Constructive Notice, Kotla Venkataswamy versus Ramamurthy. This case was held in the year 1934. The case was filed against the directors of the company. Let us go through the case. It was written in the Articles of Association of a company that all deeds and other important documents should be signed by 3 officers of the company, namely the managing director, the secretary, and the working director. These 3 people's signature was mandatory. The company executed a mortgage deed. Mortgage means loan on immovable property. This mortgage deed was signed by the secretary and the working director only. Later on, when the company being wound up, the mortgagee claimed his right on the mortgage. But the court held that the mortgagee could not claim any right under the mortgage deed, as it was invalid. The court observed that he consulted the articles of association, he would have known that such deed was required to be signed by 3 officers of the company. But in reality, it was signed by only 2 officers. So he could not claim his right. I hope this explanation of the doctrine of constructive notice will be helpful to you. Thank you very much for listening and watching.